But you know, it may be appropriate that we have a motion to approve or not the work of the task force as it stands right now. I don't know.
Move to approve the draft ethics ordinance in its current form.
Is there a second? Any discussion? All in favor?
Aye.
Aye. Okay. Item number 2, discussion of response to the Commission's decision in the matter of Whipples, Fugan versus Arbanis et al., dated August 23rd, 2006. I guess I'll start the discussion. Mr. Whipples Fugan, at a meeting of the task force, actually, passed to us some documents that indicated that that there was not full compliance with our recommendations in that case back in August. So out of that, I think 2 questions arise. One is, have they complied with our recommendations? And to that effect, I sent a letter to Jim Wirken a couple of months ago asking him to give us kind of a status report on it. Didn't hear anything till, I guess, yesterday. This letter came from him, to me, which indicates that they had complied with, and I can read it to you. Well, you guys want me to read it? I've got to be able to get a copy someplace so everybody can have one. He says, "Dear Mike, I'm in receipt of your letter dated April 27, 2007 regarding the above referenced matter. I apologize for the delay in my response as I've just been inundated with work recently. In October 2006, we opened a separate file in our office for the countersuit, and at that time transferred all substantive time entries that were related to the countersuit from the main file to the new countersuit file. Since that date, if any legal work that was done for the countersuit, it would have been billed to this separate file, and the individual legislators would have been billed directly for the time. There has not been any substantive work done in our office regarding the countersuit since October 2006. However, it is my belief that the attorney-client privilege prevents me from disclosing to you any specific information regarding which individual legislators have paid and how much each legislator has paid. Since you have ruled that this is a private matter, I am not at liberty to disclose my client's confidences without their permission. I'm in the process of getting permission to disclose this information and will respond further to your letter after I've gotten permission from my clients. Should you have any additional questions or should you need any additional information, I would be happy to provide it, assuming it does not violate the attorney-client privilege."
What was the date that he said he opened the separate file?
He just says October 2006.
And it went back to August 06?
Our decision was August 23rd of 2006. I think we need a little more clarification on it. I understand his concerns with the attorney-client privilege. I would hope that that nevertheless we can still get some confirmation that our recommendations were either followed or not. The other concern that I have, and I don't know about you all, but is partly because of the nature of, again, that attorney-client privilege, where Mr. Whipples Fugan got his information, and did that violate any privileges or any confidentialities?
Can I answer that?
Well, not yet.
Okay.
So that's kind of the opening of the discussion, and I don't know how you guys see it or what your thoughts are on this. Those are my 2 concerns.
State your first one again.
Exactly where is this whole thing? Have they fully complied or partially complied or intend to comply or have not complied? You know, I mean, all we can do is, at this point, is make recommendations to people. It's not enforceable necessarily, but certainly advisable that they follow them.
And I think one of the things that we ought to do is we ought to define what compliance is. You see what I mean?
Yeah.
What did we tell them to do?
As I recall, the monies to be paid by the individual legislators were to reimburse what had already been paid, or no? No, it was they refunded that money to the county, but the services had been rendered. So as I recall, our ruling was that, or our
Had to be
recommendation was that if they didn't pay Wirken and those guys for their work, then in effect that would amount to getting free work.
Because they're legislators.
Right. I didn't state that very artfully, but
I think we got it.
Are the recommendations.
the author of the
Thank you. How do you want it?
Just pour it. Thanks. You want some more, Robin?
No, I'm fine, thank you.
There you go.
Thank you so much.
You're welcome. I learned how to do that as a child when I was in all-day child labor in a restaurant.
you guys want me to read this?
Yeah, could you?
Yeah.
Recommendations and orders. Number one, based upon the above findings of fact and conclusions of law, the Commission hereby makes the following recommendations and enters the following orders. Number two, based on findings that county funds were inappropriately used to pay the Wirken Law Group for the preparation and prosecution of a private counterclaim for malicious prosecution that would benefit the respondents/defendants in the case of Stringfield versus Spino. We note that any violation is mitigated by the fact that prior to the hearing, steps were taken to correct that matter, in that a credit was made from the Wirken Law Group back to the county. Further, although the respondents may have encouraged the counterclaim, we do not find that they intended to violate the charter. Based on that finding and the mitigation of the findings by those factors, it is the recommendation of this body that the following steps be taken. A, that the Wirken Law Group from this point forward keep totally separate billing records of work done on the counterclaim as opposed to the straight defense of the respondents/defendants in the case of Stringfield versus Spino. Am I saying that? Is it Spino or Spino? Spino. B, that the respondents herein be required to be responsible for all past and future fees related to the preparation and prosecution of the malicious prosecution counterclaim. And C, the method by which respondents discharge their responsibility for legal fees or any contract between the Wirken Law Group and the respondents is a private matter between those two parties over which this Commission has no authority nor makes any recommendation. 3, we further order that the county and respondents cease and desist from any further violation of the Jackson County Charter in this matter with regards to that part of thereof which states, quote, no officer or employee of the county, whether elected or appointed, shall in any manner whatsoever be interested in or receive any benefit from the profits or emoluments of any contract, job, work, or service for the county. No such officer or employee shall accept any service or thing of value directly or indirectly from any person, firm, or corporation having dealings with the county upon more favorable terms than those granted to the public generally, close quote. Then it just cites Article 13, Section 1 of the Jackson County Charter. These findings, fact, conclusions of the law and recommendations and orders are entered this blank day of blah, blah, blah. I guess maybe the critical part here is B, that the respondents herein be required to be responsible for all past and future fees related to the preparation and prosecution of the malicious prosecution counterclaim. I guess that's the primary question. I mean, just on the face of Wirken's letter, and we may need some authentication to it, just on the face of that, it would appear that they've ceased the inappropriate billing practice. But as to whether or not past and future fees have been paid, we don't know.
Yeah. Yeah, because if in fact they open a separate file and bill to that separate file, then A, at least superficially, is satisfied. And the only thing outstanding is the fee issue.
Yeah.
I would think.
That's on the one hand, and then Carol, to answer your question, my second concern again was where Bob got his information and the authenticity of that, and it causes in my mind to wonder whether or not we should have a hearing on both sides of this equation, and I don't know how you all feel about it, or if there's a simpler way to solve it.